Hello. This is the first of a series of short videos I will be doing to highlight individual legal precedents set by the Supreme Court of Canada that contribute to the framework of unjust prosecutions and wrongful convictions in the area of sex crimes. But before you proceed to watch this video, I recommend you watch my short video, A Quick Primer, Canadian Legal Precedents and What the R Means, to help you understand the premise of a legal precedent if you are at all unclear. The case I'm highlighting today is R v. Ewanchuk, 1999. This is my personal interpretation and analysis on why the precedent set within this case should be overturned. The issue at the heart of this case was implied consent in a disputed scenario of alleged unwanted touching, also known as sexual assault level 1, taking place during an informal job interview. It determined two things. First, implied consent is not a defense. And second, consent is based purely on the complainant's state of mind. With that, all she has to do is claim that she did not consent, and that automatically shifts the burden onto the accused to disprove her claim, but without the legal defense to do so. This is particularly harmful in a case where the accused admits to the touching. Before this precedent was set, judges would typically analyze and assess the reasonableness of the complainant's claim of fear in comparison to the accused's testimony in the absence of any corroborating evidence that a crime took place. Regardless of the circumstances of the Ewanchuk case itself, the courts are now bound, in any sexual assault case where consent is disputed, to accept a complainant's declared fearful state of mind as the truth, and this becomes the basis of which to convict the accused. Actus reus and mens rea have essentially become moot, and the burden for the Crown to prove it no longer exists, except for perhaps the degree of criminal intent behind his touching that would only later inform the harshness of the sentencing. The most alarming line from the Supreme Court judge's decision reads as follows. As irrational as a complainant's motive might be, if she subjectively felt fear, it must lead to a legal finding of absence of consent. In other words, if the complainant says to the police and to the court that she was fearful, regardless of her actions suggesting otherwise, that is all that is needed for the Crown to have a reasonable prospect for conviction and for a judge or jury to convict. This precedent was put in place with feminist-driven ideology that it is a myth or a stereotype to assume that a woman experiencing unwanted touching should take reasonable steps to remove herself from the situation. It assumes that because the unwanted touching is by a man who might be bigger than her, it automatically creates a power imbalance of which the woman is too weak to overcome on her own. Again, regardless of any testimony by the accused that may suggest otherwise. This feminist ideology suggests that this power imbalance means women automatically experience fear in the presence of a man. The R v. Ewanchuk precedents enforce this terribly unfair and misandric myth. This precedent also supports putting one's state of mind on trial, automatically preferring the state of mind of the accuser, and shifting the burden to the accused to prove his innocence. We saw this underlying rule of law play out in the Gian Gomeshi case. His accusers all claimed they felt fear. That is the reason the case went to court, thanks to R v. Ewanchuk. Lucky for Gomeshi, he was indeed able to cast enough doubt on the accuser's claims for the judge to acquit him. However, the judge could not confirm nor deny the accusers felt genuine fear as they claimed, thanks to R v. Ewanchuk. In my view, a declared state of mind should never go to trial, unless there is affirmative and incriminating, absolutely corroborating evidence to prove the accused crossed a legal line. I hope my argument is strong and convincing for overturning this case, Please feel free to discuss it in the comments. Sources to read further into this case and the precedents it set out are listed below in the description bar, as is always the case in all my videos.